Sophia, please.
Thank you very much. It's an honor to be here with you all, and an honor to be speaking after Professor Meyer, after such an eloquent and thoughtful presentation of purpose. What I hope to bring to this conversation is a perspective of Europe and North America on these conversations, Europe being really coming from a different perspective than what we see in the UK, but also what we observe in the United States. Before that, I just thought it would be helpful to remind everybody three things that I thought were particularly noteworthy from Colin's speech. That one was really the focus on distrust, and that if there's a conversation on purpose, it's because there is a real deep sense of distrust. And the distrust is not just vis-a-vis corporates, the company issuers. It's not just vis-a-vis management. It's also vis-a-vis investors around the world that have appeared to be too short-term and generated some of the inequities and inequalities that Professor Meyer discussed. It's also a distrust vis-a-vis policymakers that maybe haven't fully embraced some of the topics and the issues to address them and address the issues that society is pushing them to. And as a result, we're having this conversation so that we can all together find a solution to address some of these major societal issues, externalities as some would call, and that companies need to play a major role in. The primary difference, and I just thought it might be helpful from a historical perspective, the primary difference is really, I think, from a legal and financial cultural perspective. So in the European markets, very often we have a civil law system. And the civil law system in society, the corporates very often, their purpose was really to society. It was never particularly to shareholders, it was society. It was what they called the intérêt social. It's what was embedded in the Napoleonic Code. And we can find that in many countries around the world that have used the Napoleonic Code. What we found, though, is that for years, as they were looking to the notion of investors in the 1980s, we saw in many markets a development of a strong investor base. And so the shift went from society to shareholder returns. And right now, the pendulum is swimming back. And it's swinging back not just in domestic markets, but it's also swinging back at an EU level. And the European Union has been particularly forceful in its conversation to address some of these issues, whether it's governance, whether it's climate change, whether it's diversity, and disclosure on those topics. And I think that is a major shift that we're seeing. And we're seeing local legislation adopt rules and laws that require companies to either think about purpose, that they ensure that the boards have that conversation with stakeholders. And that really shows this balance and complex balance between policymakers and corporates and investors. And so what we are really seeing in Europe is not just the idea of purpose, but we're seeing it something as an ongoing discussion and something that companies are pushing forth and that boards are addressing. But purpose just cannot replace performance. And so I think this is what Professor Meyer was really trying to point to as well, was it's one thing to have purpose, but at the same time, you really need to make sure that that purpose is embedded in the corporate strategy and that there are real indicators to show that this actually makes sense for the business. It also is a purpose that I think one thing we haven't really talked about, but a very good tool to attract and retain talent. This is something that we're seeing in many markets, and particularly in the United States, but also in Europe as well. The US and the UK, I think, come from a very different perspective. So while in Europe, not in all countries in Europe, but while in Europe, many countries had a civil law system where if you look back in history, if a company did anything wrong, it would generally fall under a criminal code versus a civil code with damages and compensation to investors. The UK and the US has a very different approach, and it's a civil law framework. Also different from that is the UK has and the US have a very strong institutional investor base, very deep and very liquid financial markets. And so the weight of investors has always been stronger than what you've seen in the European markets. And on top of that, as Professor Colin Meyer pointed out, is that the economic and financial philosophy of the 1950s and on has really dominated and really permeated the global markets, which is the purpose of the corporation for a long, long time. And until today, I think, and even maybe in many respects today, has been about shareholder value. What we're seeing, though, is that the social inequality, aggravated, of course, by the pandemic, as was pointed out, the societal movements, many things that have made the headlines around the world in the United States are pushing companies and leading companies to rethink the social purpose. And the Business Roundtable, as was mentioned earlier, is just that. It's that embodiment of that change of philosophy. And I think we can't underestimate the power of the statements of the Business Roundtable, because it's not about pushing back investors. It's about rethinking the corporation and rethinking the corporation to back what existed prior to the Milton Friedman era, where there was a notion of purpose, there was a notion of stakeholders. And what we've seen in the United States and in the UK, which is not really surprising, is two very important frameworks. One is the Task Force of Climate Financial Disclosure, the TCFD, which is used now by investors and has been recently adopted and declared mandatory in the UK. That is an incredible framework to incorporate disclosure on climate-related risk and financial disclosure on climate-related risk. And then the other initiative is SASB. It's the Sustainability Accounting Standards Board. And what there is another framework. And what that shows is a very different approach between these two markets. While in the UK and the US is the notion of creating standards, creating frameworks so that investors can navigate it, also a way to process that information so that they can measure it and also measure their financial impact, because at the end of the day, that's what investors need to do. It also gives a roadmap to companies on how investors are thinking about it. And it's no surprise that SASB recently translated its standards in several languages, which really shows the push that SASB is making to become a global framework. And what we can expect when it comes to purpose is going to be this tension between materiality and meaningful. And I think it's going to be also another cultural difference between what US and UK investors expect, and they dominate global markets today, versus what other countries are thinking about in terms of purpose. And I think it's mindful to think about that as we move forward. One other point I'd like to bring up, which wasn't addressed, but it kind of sets the stage to what we should anticipate in the future, is the role of technology. And technology has done many things. One is it has been a tool to amplify some of the issues that we have all observed, whether it's the societal movements, injustices that people have been able to witness, but also corporate wrongdoings, any forms of malfeasance. And so those things are now increasingly not just uncovered, but they're also increasingly shared. And their impact on companies is massive. So that technology, that push for technology, is also something to think about as one thinks about purpose. Because if the purpose isn't real, if the purpose isn't authentic, as the Professor Meyer pointed out, but if the purpose isn't materialized and operationalized in strategy, then that will come out at one point and will have some kind of significant backlash. on the companies that promote a purpose that is not real. But the second aspect on technology is how easy and inexpensive or cost-effective it is for investors to use, but also companies to use to collect data on a wide range of topics so that they can actually find relations and causality between different themes that they probably didn't think about maybe 10 years ago or couldn't have been able to access 10 years ago. And this tool of technology really provides boards, management, investors, and policymakers with incredible information to make better informed decisions, particularly when it comes to purpose. So what are the issues in terms of the board? And I think that's really, to me, at the end of the day, the purpose. So once the company determines its purpose, very often, and this is something that we're seeing in many markets, is that the board needs to be involved in that definition of purpose. That conversation needs to be had also with the board, not just with the people outside, but also with the people inside. Because the role of the board is to oversee the strategy. Sometimes it's even to set the strategy, depending on the markets. But to oversee it, it's also to reward management. And so the board's role is to incentivize that management. And to the extent that purpose can be translated into key performing indicators or to objectives that can be defined and measured or assessed in a certain way, then the board has a very important role to play. The board is also responsible for engaging investors. And increasingly in markets, directors speak to investors directly. And the topics of conversation are no longer just limited to executive compensation, as many people thought in the past. They're increasingly about purpose. And the pandemic only increased that. The issues, the societal impact, but also impact on employees, impact on business, impact on customers, impact on supply chain. And so this conversation is a conversation that directors have with investors as well. And I think at the end of the day, if the board doesn't play its role effectively with management as a good sparring partner, but also doesn't understand the concerns of other stakeholders outside the organization, and to the extent it's possible that those stakeholders have access to the board as well, then the risk is that the purpose becomes something that's theoretical, that is not part of the strategy, that is no longer meaningful, and that cannot have a measurable impact. Thank you.
Thank you, Sophia. It's a very useful presentation. And then let's move to Professor Tanaka's comment. Tanaka-san, please.
Thank you very much. Nice to meet you. My name is Wataru Tanaka. I'm a professor of law at the Institute of Social Science at the University of Tokyo. I feel very honored to be a commentator for Professor Mayer's interesting and thought-provoking presentation. And since I am a corporate law professor, in this comment, I'd like to introduce some basic aspects of corporate law and generally the general paradigm of corporate law. And then I will have several comments and questions to Professor Mayer. And in today's presentation, Professor Mayer advocates for the change of paradigm of corporate law. So I'd like to first introduce the basic structure or paradigm of corporate law. Generally, the purpose of a company or for-profit stock corporation has been traditionally understood as to maximize long-term interest of shareholders. This principle is called shareholder primacy. And in order to achieve this goal, corporate law provides two basic structures. One, shareholders have a control power over a company. Especially, shareholders have a power to appoint and remove directors. And the second, directors have a fiduciary duty to maximize long-term shareholders' interests. This is not to say that directors must pursue short-term profits. Rather, in order to maximize long-term shareholders' interest, directors can consider and pursue the interests of other people. For example, they can pursue employees' interests in order to encourage employees to work hard or make some firm-specific human capital. But shareholder primacy does require that directors cannot pursue those people's interests on their own. They must pursue their interests in order to maximize long-term shareholders' interests. Well, you may wonder whether or to what extent Japanese law follows this paradigm. In my understanding, corporate law in Japan generally supports shareholder primacy principle. Courts agree that directors are fiduciaries of shareholders and the shareholders are owners of the company. And in a context of corporate control, shareholders should make a final decision who will control the company. But of course, there is a caveat. Legal doctrines and business practices may have been very different. Since World War II, at least through 20th century, shareholders' control had been substantially limited by cross-shareholdings. Now, I move to the analysis of possible problems brought by shareholder primacy. That is very related to today's Professor Mayer's presentation. One problem might be shareholders myopia or short-termism. Shareholders may demand short-term profits and demand the company to return the profits by dividends to the detriment of the long-term firm value. And the second is a negative external effect. Companies and shareholders' control may pursue profits at the sacrifice of interests of third parties, including future generations, such as climate change or other types of damages to the environment. So, let me ask for some questions. One is how serious are those problems? There are at least several professors, law professors, especially in the United States, who have questioned how serious the short-term problems are. Like Professor Bevchuk at Harvard Law School or Professor Lowe at Columbia University. I think this is a real problem, but this is mostly empirical. So today I'd like to focus on the next question. The question is, won't changing corporate purpose lead to another problem, especially weakening discipline of the management? Traditionally, Japanese firms had been under less pressure from shareholders than US or UK counterparts. But have they succeeded more in increasing the long-term firm value? In 1980s or in early 1990s, US corporate governance systems were also severely criticized. But in those days, quite a few prominent scholars, such as Michael Porter, argued that US firms must learn from Japanese firms. Nowadays, few people make such an argument. Low profitability and growth rates in Japanese firms and Japanese economy at large have substantially degraded traditional Japanese corporate governance systems. So if we deny or at least leave from shareholder primacy, what assures discipline of the management? This has been a question I have prepared for my comment, but in today's presentation, Professor Mayer said that there is no trade-off. There is no trade-off between efficiency or profitability and interest of third parties or interest of third parties or against short-termism. Professor Mayer seems to think that the new paradigm requires a board to achieve their purpose with maintaining profitability of the firm. If my understanding is correct, then this leads me to wonder: is this a real change from the traditional paradigm of corporate law? Traditional paradigm of corporate law requires directors to pursue long-term interests of shareholders. It requires a value, long-term value of the firm company. So if the new paradigm of Professor Mayer does not require the board to pursue the profitability, then to me, his new paradigm does not look very different from the traditional paradigm of corporate law. I might misunderstood Professor Mayer's view, but I'd like to ask more from him what a new paradigm of corporate law really means. Thank you very much.